Okay, good afternoon. Thank you all for coming. Thanks so much for being here. My name is Blake Rocap. I'm the director of the Sissy Farenthold Reproductive Justice Defense Project. We're a project of the Sissy Farenthold Fund for Peace and Justice, which is housed at the Rapoport Center for Human Rights here at the law school. So thank you to Professor Karen Engel, the co-director of the Rapoport Center, for giving us an institutional home for this work and all her support. We're really lucky to have Helen Jennings here today. She's in town for a public law conference, and she's presenting tomorrow morning also on a different human rights topic. So we twisted her arm to come over here and talk what I wanted to hear about, which is the current issue analyzing California's attempt at making reparations to folks they involuntarily sterilized in most of the 20th century. Helen is a barrister, a current doctoral student, and a reproductive justice advocate. She played an active part in the campaign to legalize abortion across the island of Ireland with the London Irish Abortion Rights Campaign. She studied law as an undergraduate at the University of Cambridge and graduated with an LLM from NYU in 2021 as a Fulbright scholar. She's worked at the UN Women as a legal researcher, for UN Women as a legal researcher on various topics related to women, peace, and security, and has published papers on non-consensual sterilization and U.S. immigration detention, and on UN fact-finding as a mechanism to secure justice for victims as rape as a weapon of war. She completed her pupillage at 25 Bedford Row Chambers in London as a criminal defense barrister before completing a clerkship at the Supreme Court of the United Kingdom. She's currently pursuing her doctoral degree in the JSD program at the University of California, Berkeley School of Law, and continues to write on issues related to international human rights, transitional justice, and reproductive justice. Please join me in welcoming Helen Jennings.
Thank you so much, Blake, and thank you to you and to Karen and to everyone else who has welcomed me so wonderfully to UT Austin School of Law. I'm so excited to be here. In 2021, the California State Legislature approved a reparations scheme for victims of forced sterilization carried out from 1909 to the mid-2010s. As the window for victims of forced sterilization to apply for reparations has recently closed in December 2023, it's now time to assess the efficacy of that initiative. I'm workshopping a paper with you today, and I'm hoping to get lots of good questions and insights so that I can make it much better than it already is, to evaluate the reparations scheme through the lens of transitional justice, which is a field of international law describing the process through which typically a state attempts to reform and repair relations with its citizens following a mass human rights abuse, conflict, or political regime change. The four defining pillars of transitional justice theory are truth, justice, reparations, and a guarantee of non-recurrence. In my view, the California State Legislature is engaging in transitional justice by creating the reparations scheme and attempting to address the historic harm caused to its citizens who were non-consensually sterilized. The paper I'm writing will assess the extent to which this engagement has been successful and suggest lessons from transitional justice that can be applied to California's public policy reckoning with the legacy of eugenics. At this stage of writing the paper, I would like to discuss with you today the legislation laying out the reparations scheme, known as AB 1007, and to share my initial thoughts on whether the goals of transitional justice are being met or even pursued by the state of California in relation to historic forced sterilization. At the outset, I want to share my utmost admiration for the reparations scheme, and in particular, the grassroots community groups, including survivors of forced sterilization who campaigned tirelessly for reparations. They offered testimony before the State Senate to inform the drafting of the bill. They assisted with the drafting process and co-sponsored the bill. And in particular, if you want to engage further with this issue, I urge you to look at the work of California Latinas for Reproductive Justice, Back to Basics Community Empowerment, California Coalition for Women Prisoners, and the Disability Rights Education and Defense Fund. I will also recommend highly the Emmy-winning documentary film Belly of the Beast, which brought the stories of survivors of forced sterilizations in California prisons before the widest audience possible, and presents those stories with the utmost care and respect, while still fully conveying the shocking nature of forced sterilization as state violence. Highly, highly recommend that. So, to begin with an overview of transitional justice, I've already let you know that the four key pillars are truth, justice, reparations, and guarantees of non-occurrence. And I'm going to be addressing each of these pillars in turn while analysing the reparations scheme. Starting with truth. The pillar of truth in transitional justice typically describes mechanisms such as truth commissions and public inquiries, which have been used to build and promulgate an accurate and comprehensive shared history of events and acknowledge the experiences of victims throughout that history. This is really important if a society is to fully acknowledge and move forward from a mass human rights abuse or a conflict situation with a shared understanding of what happened and who was responsible. Section 1 of AB 1007 contains a short history of forced sterilization in California. This history begins in 1909 when California passed the third eugenics law in the nation and details the practice of performing asexualization surgeries upon patients with mental illnesses or learning difficulties, those whose sexual preferences were judged perverse by the standards of the time, and people suffering from sexually transmitted diseases. The history included in AB 1007 is damning. It details the lack of oversight over 12 state-run homes and hospitals that housed patients who had been placed in the state's care by their families for mental deficiencies or illnesses. In some of these institutions, sterilization was a precondition of release if the patient or their family wanted to return to the community. California's sterilization laws were explicitly motivated by eugenics, a policy movement which sought to reduce the number of so-called defectives in society, resulting in cost savings for welfare programs and to only allow fit people to become parents. The history of eugenics laws offered in AB 1007 acknowledges that these laws were applied disproportionately to racial and ethnic minorities, people with disabilities, poor people, and women. More than 20,000 Californians were sterilized under the eugenics laws, which were enforced between 1909 and 1979. The history section of AB 1007 also addresses more recent history. Long after the Californian eugenics laws were repealed in 1979, the practice has continued in state prisons. Between 2006 and 2010, at least 144 people were sterilized in California's women's prisons during childbirth without adherence to informed consent protocols, sometimes without translation for non-English speaking detainees, and disproportionately among women of color. This history creates two distinct groups of potential reparations recipients under the scheme. And I'm going to speak soon about the distinct difficulties that arise for both groups seeking the compensation that they are due. The history section of this legislation offers the history and places it in the public record with the affirmation of the California State Legislature and can be commended from a transitional justice perspective for its detail, for its unflinching approach to the facts, and for its clear condemnation of the eugenics laws and the officials who administered them. However, I don't think that this history satisfies the aspirational demands of truth-seeking from a transitional justice perspective. There are two crucial elements missing from the public record. Firstly, the direct testimony of victims and survivors. And secondly, an element of public promulgation, dissemination, and education once the truth has been discovered. As I've already mentioned, the reparations scheme was drafted with the heavy involvement of several advocacy groups. This level of participatory involvement is fantastic from a transitional justice perspective, and their tireless advocacy on their own behalf as victims of forced sterilization deserves every praise. However, those victims have not been offered a platform or a forum by the state to tell their stories publicly, should they wish to do that. I don't think that AB 1007 would have been the correct space for those testimonies to be listed, but there are no personal testimonies or any individualization from the history of forced sterilization that the state has now endorsed. The testimony of forced sterilization survivor Kelly Dillon, whose case is the focus of the Belly of the Beast documentary, proved crucial to inform the drafting of another bill, SB 1135, which was passed in 2014, prohibiting the sterilization of inmates in California prisons for the purpose of birth control. But no testimony was publicly taken during the drafting of AB 1007, the reparations scheme. It may have informed the drafting behind the scenes, but there has been no public promulgation of those testimonies. Victims and survivors ought to be offered a platform by the state of California to enter their testimonies into the public record, receive acknowledgement from the state, receive an apology, and gain assurance that their story will be used to educate the Californian public, such that a resurgence of eugenics practice never reoccurs. This could take the form of a public and televised hearing in the legislature, informing a report and educational materials which are widely disseminated. Without this process, survivors are left without individual acknowledgement beyond the fact of a ruling on whether or not they are deemed eligible for the program. Furthermore, the bill includes numerous calls imploring every citizen of the state to educate themselves on the history of eugenics. But without state investment in those education programs, the onus is shifted onto individual citizens to undertake that education themselves, when really it should be the responsibility of the state as part of their acknowledgement. Another crucial aspect of truth-seeking in the digital age is also an assurance of privacy by the state for truths disclosed as part of an investigation into historical harm. Shockingly, however, in December 2022, a data breach in the California State Archives left exposed the personal information of victims which should not have been in the public domain. This is a huge failure, which is not part of the scheme itself as laid out in AB 1007, but it's still important to mention as part of the truth-seeking process. Moving on to justice. In transitional justice, the justice pillar represents retributive, compensatory, or restorative justice measures that are made available to victims or survivors of historic harm, usually through the criminal and civil justice systems. No such measures have satisfactorily been made available to victims of forced sterilization in California. In relation to historic sterilizations carried out under the eugenics legislation, class action lawsuits such as Madrigal and Quilligan showed that it has been possible to bring a claim against state-run medical centers for forced sterilizations, but these claims are very difficult to prove due to the historic nature of the abuse. In Madrigal and Quilligan, 10 Mexican-American women sued the LA County Medical Center for having non-consensually sterilized them. The California federal court ruled in favor of the medical center and held that the sterilizations were the result of miscommunication and language barriers between the patients and the doctors. Similarly, Kelly Dillon brought a case against the doctor who sterilized her when she was in prison when she was 24 years old. The court did not find that doctor liable for her sterilization after a jury trial. Justice via civil jury trial is difficult to obtain for historical wrongs. Not only can cases run afoul of statutes of limitation, and this did affect some of Kelly Dillon's claims, but the further in time a case is brought from sterilization, the more difficult it is to gather evidence proving that the procedure took place in the manner alleged by the victim. Measures to extend statutes of limitation for historical wrongs have been applied within the context of historical institutional child sexual abuse. And I would argue that these are transitional justice measures. Just to let you in, the other aspect of my research is on historical child sexual abuse and applying transitional justice to that context. So there are contexts in which the statutes of limitation have been purposefully extended in order to allow historical wrongs to come to court. These measures change the rules as normally applied to civil wrongs to account for this specific widespread wrong and create a pathway to justice. And this could be applied in the forced sterilization context. The evidential difficulties which apply to criminal and civil justice also affect the reparations scheme itself, which I will now discuss. In transitional justice processes, reparations for victims can include fiscal, non-fiscal, and symbolic measures. A symbolic measure might be the provision of death certificates for people who have gone missing during a war, for example. When evaluating the reparations scheme, it's helpful to consider separately the scope and the operation of the scheme, and to consider separately both groups of potential victims that may claim under the scheme. The reparations scheme can be praised for including both historical victims of forced sterilization from 1909 to 1979, and modern victims who have been sterilized in state prisons. Whether or not those victims should have been put together under one reparations program is perhaps another point of inquiry. The bill exempts victim compensation payments from being considered taxable income for state tax purposes or being subject to enforcement of a money judgment. And the award doesn't affect eligibility for social benefits. And these are all excellent considerations, given that some of the recipients are former prisoners who may still be attempting to transition back into their communities. A preliminary issue with the scope of the scheme in relation to sterilizations, which happened before 1979, however, is that in order for a reparations claim to be filed for an individual, that individual must have been alive on the day that the reparations scheme began operation, that date being the 1st of July, 2021. The exclusion of relatives for deceased victims of forced sterilisation draws into question what the scheme is trying to achieve in offering reparations. Reparations for forced sterilisation are not a form of restitution. They can't ever make up for the loss that has been inflicted upon the person who has been forcibly sterilised. That loss is also not only the individual's to bear, because for family members, if the victim wished to bear children, then the family has also lost potential siblings, grandchildren, or cousins through the forced sterilisation of the victim. In the case of minority victims of forced sterilisation, particularly under these eugenics laws, there is also an enormous community loss which has been created by forced sterilisation. These laws were created to purposefully reduce the population of certain groups from Californian society, and those were disproportionately communities of colour. Reparations can never restore that loss. They cannot fix the harm, return the victim or their community that lost potential for childbearing, those lost members of the community. They can only attempt to attach a monetary figure to the harm of forced sterilisation and partially compensate the victim for the wrong committed against them. However, there's no reason, if we accept that the wrong also affects the family or the victim's community, that compensation ought not to flow to those places if the individual victim has since passed away. The exclusion of families of deceased victims of forced sterilisation is also at odds with wider efforts across California to offer reparations to descendants of enslaved people. The California reparations scheme administered a total of $4.5 million. Under AB 1007, eligible recipients of reparations were to receive $15,000 in a first payment. Then after the scheme closed, a second payment would be administered when the remaining funds were divided equally between the eligible victims. As of September 2023, that second payment was valued at $20,000. As I'll go on to discuss in a moment, the administration of the reparations scheme left a lot to be desired in itself. And reparations payments have only been offered to 113 individuals. If 113 individuals receive $35,000 in reparations payments, that's a total of $395,500 dispersed from the fund. What about the other $4 million? There was easily enough funding to extend eligibility to direct next of kin for deceased victims, or even for investment into directly affected community advocacy groups. Of course, the fact that only 113 victims of forced sterilisation will receive reparations raises the most pressing concerns around both the scope and operation of the scheme. There are two reasons I propose for the low number of successful applications to the scheme. Firstly, the high evidential standard applied to these claims, which are, as we've discussed, uniquely difficult to prove as they contain historical wrongs. And secondly, failures with the administration of the scheme. The reparations scheme requires applicants to submit evidence proving their eligibility. Difficulties abound when it comes to applicants who claim to have been sterilised before 1979 under the eugenics laws, as poor record keeping during this time can lead to victims' medical history being incorrect or incomplete. Accessing these records can also prove difficult because some of the state-run hospitals and homes operated during that period have since been closed, and those records have been lost. In relation to individuals sterilised while in prison, different concerns arise. As these sterilizations took place after 1979, there is a greater chance of there being accurate medical records kept within state prisons. However, the issue in these cases relates to proving that the victim did not give their informed consent to the procedure, or in the language of AB 1007, that the procedure was not required for the immediate preservation of the individual's life in an emergency medical situation. The emergency medical situation exception is a major issue in prison sterilization cases because there is proof of doctors fabricating medical emergencies in order to justify sterilizing prisoners. A 2013 report by the Center for Investigative Reporting found that the state paid prison doctors $147,460 per patient to sterilize patients between 1997 and 2010. One Dr. Heinrich, who regularly charged the state this sum when he sterilized women, justified those actions by arguing that that's actually not a huge amount of money when compared to what the state saves in welfare paying for unwanted children as the prisoners continue to procreate. He justified sterilizing prisoners as a saving of tax dollars. The Center for Investigative Reporting even obtained a direct quote from a nurse who worked for Dr. Heinrich, confirming that they would fabricate medical emergencies in order to justify sterilizing prisoners. On a couple of occasions, he brought an issue to me saying, "We ought to have a tubal ligation. She's got 6 kids. Can we do it?" And I said, "Well, if you document it as a medical emergency, perhaps." How are victims supposed to prove that they were not sterilized due to a medical emergency when their doctors may have fabricated records to say so? This is a major oversight in the prison sterilization eligibility criteria under the reparations scheme, and no provision was made in the scheme. For example, a medical review board to assess the evidence for potential inconsistencies between the medical history of the victim and the decision to sterilize. The California Victim Compensation Board, which is the body overseeing the process of reparations and also making the determination of eligibility for each individual application, is a body consisting of 3 board members and 7 staff members. This board is also in charge of overseeing the General Criminal Victims Compensation Scheme for the whole of California, and each of the board members also have separate full-time jobs. Let me remind you that over 20,000 Californians were sterilized under the eugenics laws from 1909 to 1979, and an estimated 1,400 individuals may have been sterilized in state prisons until 2010. The scale of this harm is easily large enough to justify a UN Commission of Inquiry, for example, not the efforts of 3 part-time and 7 full-time workers splitting their attention between this and other projects. The board had no resources to gather evidence or investigate on its own under the legislation, and could only review the evidence brought before it by applicants to the scheme or conduct databases of potential victims compiled by organizations such as the Sterilization and Social Justice Lab at the University of Michigan or records in the state archives, which we've also proved because of a data leak are not secure. Moreover, the reparations scheme only accepted applications from July 1st, 2021 to December 31st, 2023. That's 18 months in which all the victims of forced sterilization in California had to hear about the scheme, realize that they might be eligible, bearing in mind that some of these people may not still be aware that they were ever sterilized, access their own medical records, put together their application and submit it. The extremely restrictive timeline for the administration of the reparations scheme no doubt led to potentially eligible victims being excluded. Unsurprisingly, given the lack of time and resources, the California Victims Compensation Board failed to adequately advertise the scheme, and many of those responsibilities entrusted to the board under the statute actually fell to the community groups who had tirelessly advocated for the scheme in the first place. Those groups were forced to advocate on an unpaid basis for the reparations scheme to reach the most vulnerable potential victims, including people still incarcerated. From a transitional justice perspective, this wholly undermines the state's taking responsibility for the harm committed if its under-resourcing of the reparations scheme continues to force community groups, including people who were sterilized themselves, to fight for equal access to compensation. Finally, I'll consider the measures that the state of California has put in place to assure victims of forced sterilization that these practices will never happen again. Guarantees of non-occurrence are not just comprised of statements by the party responsible for the historic wrong, but should include action taken to ensure that those abuses will never happen again. Starting strong, due again to the advocacy of Kelly Dillon, legislation was passed in 2014 prohibiting the sterilization of prisoners for the purpose of contraception without the informed consent of the prisoner. Although it should have been obvious prior to this on a moral and an ethical and a human level, enshrining this position into statute signifies a zero-tolerance approach from the state, which might hopefully eradicate the widespread belief among prison doctors, which was recorded by the Center for Investigative Reporting, that they simply did not need permission to perform the surgery on inmates. An important gesture which spans the truth and non-recurrence pillars of transitional justice is the official apology. Without recognition and apology from the state, many victims' rights groups across transitional justice case studies have considered monetary compensation to lack meaning and simply appear as the state throwing money at the problem. On March 11th, 2003, Governor Gray Davis apologized for California's eugenics sterilization program, and Attorney General Bill Lockyer issued an apology on the same day. Yet, in regard to prison sterilizations, it has been acknowledged in the text of AB 1007 that the state has not issued an apology for coerced sterilization of people in women's prisons occurring after 1979. This failure is unjustifiable by every measure. Thank you very much for listening to my thoughts on this topic and my critiques of the reparations scheme as the sole mechanism by which the California State Legislature has substantively engaged with this legacy. As I've said before, this project is in the early stages. I've pointed out where the reparations scheme has struggled on its own terms to identify and compensate victims. It's not too late for the scheme, in my opinion, and perhaps the state legislature will choose to extend or restart it to reach more victims. My main suggestion, however, is that the California State Legislature has failed to utilise the full spectrum of transitional justice policy measures to address the legacy of eugenics. I propose that the state legislature should develop a holistic response in a participatory manner with victims and advocacy groups to include other transitional justice mechanisms, such as a public truth seeking exercise, memorialization, public apology, and community investment. Thank you so much.
Thank you so much, Helen. That was wonderful. I'll let you stay there and let you handle your own questions. I know people have questions and comments. I'll let you continue to run the room here. I don't mean to be in your way.
Absolutely. Please.
Just a clarifying question to start. So what did they do to notify, other than the actual organizations going out to do it, what did the state do to notify?
So the state had a website and they issued flyers in prisons. But most of the advocacy, and this was recognized throughout the administration of the operation of the scheme, most of the advocacy was done by those community groups, and those groups themselves who had advocated for the scheme and who are the biggest supporters of the scheme recognized at that stage that the state had failed to meaningfully apply resources and effort into promulgating that information. So they were the ones to actually go into prisons and hold talks and outreach to other community groups dealing with potential victims groups, and they were the driving force.
I have two questions about the non-recurrence. Is there still a medical exception or medical emergency exception regarding sterilizations?
Under the prisons legislation?
Yeah.
I'll have to look that up. I suspect that there might be, but I'm not sure.
Yeah, so, yeah, I was curious about that, given the fact that it had been like abused in the past.
Absolutely.
And then also with informed consent, that requirement, like, are there any measures laying out more specifically what's required for that? Because I know there's like issues of proving informed consent too, and I was curious, like, if it's just that statement of informed consent, or if there are like more comprehensive guarantees that it actually is informed.
In the reparations
In the,
scheme
and
or
the
in
legislation.
the
too, I think you
legislation?
mentioned. Yeah.
That's another area that I'll need to look at. I know in the reparations scheme itself, it actually has quite a sophisticated understanding of what informed consent or non-informed consent is within that context. Which again would tell me that it probably is included in the legislation, but two great questions. Thank you so much. Right. Yes,
I hate to be this dark, but do you think?
please be the star.
Do you think part of the reason why they're not choosing to include or acknowledge like the stuff happening in prisons after 1979 is because there's a potential it's still happening and they would have to like divert state resources to really enforce that policy?
You mean about the apology?
Yeah.
No, I don't think that that's, I don't think that that's an excuse because the state legislature does acknowledge that within this legislation. It's more about forum. Without that kind of public apology is supposed to speak directly to victims and acknowledge them. There has been acknowledgement of what has happened since 1979 in state prisons through this legislation. But the point of a personal apology is much more about individual acknowledgement. And I don't think there's an excuse at all for that. I don't know what the reason might be because they have already directed funds towards this, but yeah, I don't know.
And then speaking of maybe unknowable reasons, do you know maybe why this scheme was so short? Like that just seems like an insane amount of time.
I can only imagine, being my most cynical self, to limit the amount of funds that the scheme actually administered in the end. But what are they doing with the extra money? I don't know. I know that, and this is a part of the paper that I've cut out for the purposes of the talk, but halfway through the reparations scheme's operation, the senator that really pushed for the bill and was the main sponsor, actually made a statement that some of the funds were going to be reappropriated and opened back up towards offering reparations towards victims of a specific hospital, which wasn't state run. Because there was a period of time in this hospital that 240 people were sterilized within the hospital, but it wasn't state run and it wasn't directly under the auspices of the eugenics laws, but it wasn't justified in that way because it didn't need to be because it wasn't a state run hospital, but it was clearly part of the legacy of eugenics. However, the community groups at this stage, when they heard this public announcement, were quite outraged and quite shocked because to them, it felt like, and this is a quote from Kelly Dillon, it felt like taking food from one hungry child and giving it to another hungry child. It was splitting the resources that was meant for victims within one group and then suddenly allocating it to another because they weren't able to find enough victims within the first group. So that was just another issue with the administration of those funds that I don't know. It's clearly the state wanted to limit how much money eventually reached the victims, but I don't see how that correlates with then opening it up to another victims group as well.
It's a great project, a dark subject, but I'd love to hear more about the role that advocacy organizations played. Because I'm a little worried that the way you present it is like they pushed really hard, they got this law, which was what they wanted. And then it all went awry. So now you've suggested in the Q&A that they've been critical along the way. And maybe they were required to do much more than they ever thought they would be required to do. But have they been stating this critique? Like who else is making this critique and what is it that they're pushing for?
So because it's such early days since the scheme has come to a close, there isn't a lot of critique yet, which is the gap that I'm trying to fill at the minute. But absolutely, the community organizations have been the ones both pushing for the reparations scheme in the first place, but then as soon as the legislation was passed and the scheme opened, they were the safeguards. And they were the ones critiquing how it was being operated. They were the ones filling in the gaps and they were the ones expressing this outrage when funds seemed to be reappropriated. So I absolutely agree that I want to center those groups much more clearly within this project, but I haven't had time to be in touch with them yet. So that is the next frontier of this project for me, to get in touch with all of those groups and walk the walk of my own opinions on integrating testimony into transitional justice processes.
I can follow up that. Are they, do you know if they're trying to take some of the recommendations you make here and have the legislature take action again to either reopen the scheme, reappropriate money? You know, not just critique how it worked, but like, you know, fix it by taking more action.
Again, because it's only been a few months since the scheme ended, there haven't been public statements from those groups yet in terms of extending the scheme. But I mean, it seems like an obvious thing to push forward for me, but I'll be very interested to hear what they have to say. Absolutely.